One statement, that's all it requires. One statement during a standard traffic encounter can transform a completely lawful firearm owner into the focus of a criminal investigation. And most individuals don't even recognize it's occurring until it's too late. You believe you're being helpful. You believe you're doing the correct thing, but the instant those words exit your mouth, they're no longer just words, they're proof. And in light of a significant Supreme Court ruling, what you communicate to law enforcement about a firearm now carries even more significance than most individuals comprehend. Because this isn't just about whether you're lawfully carrying. It's about how your own statements can be utilized to construct a case against you. Today, we're examining the exact phrases that sound innocent but can quietly undermine your legal defense before you ever enter a courtroom. And more importantly, the precise language that can protect you when it matters most. Hi, I'm Sophia. And if you possess a firearm or even travel with one, this is something you need to comprehend clearly because the difference between staying protected and facing serious allegations often comes down to a few seconds of dialogue. What we're reviewing today isn't speculation. These are real patterns drawn from real situations where law-abiding individuals believed they were doing everything right until their own words were utilized against them. I'm going to guide you through 5 of the most frequent responses individuals give when officers inquire about weapons and why each one can put you at risk. But more importantly, I'll demonstrate exactly what to communicate instead so you can protect your rights without making a costly error. And stay with me because the final response is the one that causes the most harm, and it's also the one individuals communicate the most without thinking. The first response sounds so logical, so direct that almost everyone communicates it without hesitation. And that's exactly why it's so risky. An officer inquires, "Any weapons in the vehicle?" And you respond, "Yes, I have a gun." It feels truthful. It feels helpful. But legally, what you've just done is establish possession without establishing legality. And that gap is exactly where difficulties begin. Because from a legal standpoint, that statement becomes what's known as an admission against interest. You've confirmed the firearm is yours, but you haven't communicated anything about whether you're licensed, whether you're carrying lawfully, or whether you're complying with specific state requirements. And prosecutors don't fill in those gaps in your favor. They construct around them. There was a situation involving a licensed carrier during a standard encounter who gave a simple version of that exact response. He believed he was being respectful and transparent. But because his language didn't meet his state's specific notification requirement, that one statement became the foundation for allegations, not because he was unlawfully carrying, but because he failed to communicate it correctly. That distinction cost him thousands in legal expenses and months of difficulty that could have been avoided with a more precise response. And this is where most individuals get caught unprepared. The law doesn't reward positive intentions. It responds to exact language. So instead of defaulting to "yes, I have a gun," the safer approach, especially in states that require notification, is to clearly establish your legal status without adding anything unnecessary. A simple structured statement that communicates compliance, not just possession, changes how that interaction is interpreted from the very beginning. And if that feels counterintuitive, the next error will challenge your instincts even more because it involves giving what most individuals think is helpful information. Imagine the same scenario. You've already acknowledged there's a firearm, and now the officer inquires, "Where is it?" Your instinct is to reduce tension, to be transparent, to demonstrate there's nothing to conceal. So you communicate something like, "It's in the glove box," or "It's under the seat," or "It's in the center console." Again, it feels responsible, but what you've just done is provide 2 critical elements prosecutors look for: knowledge and control. You've confirmed you know exactly where the firearm is and that it's within your immediate reach. And that matters more than most individuals recognize, because if that location happens to violate a technical requirement, maybe it's not stored properly. Maybe it's too accessible under local law. Maybe there's a specific rule about how it should be secured. You've just provided the exact proof needed to support that allegation. There was a real situation where a driver volunteered that his firearm was in the center console. He had a valid permit. He wasn't trying to conceal anything. But because of how the firearm was stored, that statement became the key piece of proof utilized against him. What could have been a standard encounter turned into a prolonged legal issue. Not because of intent, but because of volunteered information. This is where understanding restraint becomes critical. You can still comply with lawful instructions. You can still remain calm and respectful, but volunteering specific location information introduces risk that doesn't benefit you. And once it's communicated, you can't retract it because from that point on, it's no longer a dialogue. It's documentation. And that documentation can follow you all the way into a courtroom. Now, here's where things get even more misleading because the next response sounds not just logical, but responsible. An officer inquires about weapons, and you communicate, "I have my permit." On the surface, that feels like the safest possible answer. You're signaling that you're following the law, that you're authorized, that there's nothing to worry about. But the risk isn't in what you intend, it's in what occurs next. The instant you make that statement, you've invited verification. And if there's any issue with that permit, something you may not even be aware of, you've just created a second difficulty on top of the first. Permits can expire. They can be suspended without your knowledge due to administrative issues like an unpaid citation. They may not be recognized across state lines the way you think they are. And if an officer checks and finds a discrepancy, your statement, "I have my permit," can now be interpreted as providing false information to law enforcement. That's a separate allegation in many jurisdictions, and it often carries its own penalties independent of the firearm issue itself. There was a situation where a driver genuinely believed his permit was valid. He had moved, missed a notice, and didn't realize it had been suspended months earlier. But because he confidently stated he had a valid permit, that statement became part of the prosecution. What started as a standard encounter escalated into a much more serious legal situation. Not because of intent, but because of assumption. And that's the pattern you're starting to see. It's not about whether you're a responsible individual. It's about how your words interact with systems designed to verify, document, and when necessary, prosecute. So instead of making definitive claims in the moment, the safer approach is to avoid locking yourself into statements that can be immediately challenged. Precision matters, timing matters, and sometimes restraint protects you more than reassurance ever could. Which brings us to the next response. And this one catches individuals because it feels like the most human answer you can give. The officer inquires why you have a firearm and you communicate it's for protection or for self-defense. That sounds logical. It sounds responsible. It sounds like exactly what you're supposed to communicate. But legally, what you've just done is establish intent. You've confirmed that the firearm isn't just present, you intended it to be accessible for use. Now, that might not sound like a difficulty if everything about your situation is perfectly compliant. But if anything is even slightly off, wrong location, restricted area, permit issue, jurisdictional conflict, that statement can be utilized to elevate the seriousness of the situation, because now it's not just about a technical violation, it's about intentional conduct. And that distinction can significantly change how a case is charged and argued. There was a situation where someone carrying in a restricted zone explained they had the firearm for protection due to concerns about crime in the area. From a human standpoint, that makes sense. From a legal standpoint, it allowed prosecutors to argue that the individual knowingly chose to carry in a prohibited space, prioritizing personal reasoning over legal boundaries. And once that argument is on the table, the tone of the entire case shifts. What could have remained a minor issue becomes something much harder to defend. This is why explanations, even well-meaning ones, can create complications you don't see in the moment, because in that interaction, you're thinking about clarity. The legal system is thinking about intent, proof, and how your words fit into a larger narrative. If this is making you rethink how these situations actually function, that's the point. Because most individuals don't realize how quickly a simple dialogue can turn into a structured case. And in the next part, we're getting into the response that causes the most harm, the one individuals communicate instinctively when they feel pressure and the one that can quietly dismantle nearly every defense you might have. The final response is the one that shows up again and again in real situations, and it usually occurs in a moment of pressure. The officer finds the firearm or the situation suddenly feels more serious and instinct kicks in. You try to de-escalate. You try to sound harmless. And that's when individuals communicate things like, "I wasn't going to use it," or "I forgot it was there." On a human level, that feels like the right move. You're trying to communicate that you're not a threat. But legally, those statements can do more harm than anything we've covered so far, because the instant you communicate, "I wasn't going to use it," you've just confirmed that you knew the firearm was there. That single admission can eliminate entire lines of defense, especially any argument that you were unaware of its presence. And when you communicate, "I forgot it was there," you're introducing a different kind of difficulty, negligence. In some jurisdictions, negligence around firearm storage or transport is itself a violation. So now, instead of reducing the seriousness of the situation, you may actually be expanding it, and it doesn't stop there. Statements made under pressure are often inconsistent. Individuals add information, they try to clarify, they communicate more than they planned, and every additional word becomes something that can be examined, compared, and if necessary, challenged. If physical proof doesn't perfectly match what you communicated, that opens the door to credibility issues. What began as an attempt to calm the situation can end up complicating it in ways that are very difficult to undo. There was a situation where a driver trying to be helpful immediately communicated he had forgotten a firearm was in his vehicle after a previous trip. That statement alone established knowledge and lack of proper handling. What could have been handled as a minor issue escalated into an allegation that followed him well beyond that initial encounter. And the critical point here is this: nothing he communicated improved his situation, but it gave the case structure. It gave it direction. It gave it something to construct on. And that leads to a reality that most individuals don't fully comprehend until they're in it. A roadside interaction may feel informal, conversational, even casual at times, but functionally, it's not. It's the earliest stage of proof collection. Every answer, every clarification, every volunteered information has the potential to be documented and revisited later in a completely different context. You might be thinking about resolving the moment. The legal system is thinking about what can be utilized later. That's why the biggest shift isn't just about memorizing what not to communicate. It's about understanding your role in that interaction. You're not there to explain your entire situation. You're not there to justify or narrate. And you're not required to fill silence with information that could later be interpreted in ways you didn't intend, because once something is communicated, it doesn't belong to the moment anymore. It becomes part of a record. And this is where that Supreme Court framing becomes important. Your rights don't operate automatically in the background. They have to be clearly and intentionally exercised. If you don't assert them, the system doesn't pause and inquire if you meant to. It proceeds based on what's available, what's been communicated, what's been observed, and what's been recorded. Which means the difference between protecting yourself and unintentionally constructing a case can come down to a single decision: whether you keep talking or whether you choose to stop. So, after everything we've covered, the question becomes simple but incredibly important. What should you actually communicate? Because in a moment like this, clarity matters more than confidence, and structure matters more than instinct. The goal isn't to out-explain the situation or convince anyone of anything on the spot. The goal is to protect yourself legally while remaining calm and compliant. And that starts with understanding that less is not just more. It's safer. If you're in a state that requires you to inform an officer that you're carrying, then your first step is to do exactly that clearly and directly. A simple composed statement that establishes your legal status without adding unnecessary information. Not a dialogue, not a story, just a clear notification. And once that requirement is satisfied, the next step is where most individuals go wrong because they keep talking. They try to help clarify, explain, or reassure. But at that point, every additional word introduces variables you don't control. The safest and most consistent way to protect yourself is to transition out of explanation and into assertion. A calm, respectful statement that draws a clear boundary. I'm exercising my right to remain silent and I want counsel present. That's it. No elaboration, no justification, no added information. It may feel uncomfortable in the moment, especially if you're someone who naturally wants to cooperate, but legally that single statement does more to protect you than anything else you could communicate. And here's why this functions. It stops the flow of information at the source. It prevents misunderstandings, misstatements, and inconsistencies from developing. It ensures that anything that needs to be clarified or addressed occurs in the right setting with the right guidance. Because once you've invoked that right clearly, the dynamic changes. The interaction is no longer about gathering statements. It shifts into a different legal posture entirely. Now compare that to everything we've discussed so far. Communicating yes, I have a gun confirms possession without protection. Communicating where it is establishes control and accessibility. Communicating you have a permit invites verification that can backfire. Explaining it's for protection introduces intent. And panic statements like, I forgot it was there, or I wasn't going to use it, can dismantle entire defenses in seconds. Each of those responses feels natural in the moment, but each one creates a layer of risk that constructs on itself. So instead of reacting, you're replacing instinct with a simple structure. Comply where required, then stop talking. Not because you have something to conceal, but because you comprehend how the system functions. And that understanding is what separates individuals who protect themselves from individuals who unintentionally complicate their own situation. Let's lock this in clearly. 5 responses to avoid and why they matter. Yes, I have a gun because it establishes possession without legality. It's in the glove box because it proves knowledge and control. I have my permit because it opens the door to verification issues. It's for protection because it introduces intent that can escalate allegations. And I forgot it was there, or I wasn't going to use it because it confirms knowledge and can destroy multiple defenses at once. Different phrases, same outcome. They give structure to a case that didn't need to exist. And on the other side of that, one clear, controlled response that protects you. You notify if required, and then you assert your right to remain silent and request counsel. Simple, repeatable, and legally grounded. Because in situations like this, it's not about communicating more. It's about communicating the right thing and then knowing when to stop. By now, you can probably see the pattern. And it's not about memorizing a list of positive or negative phrases. It's about understanding how quickly a normal interaction can turn into something much bigger based entirely on what you communicate in the moment. Most individuals don't get into difficulty because they intended to break the law. They get into difficulty because they treated a legal situation like a casual dialogue. And those are 2 completely different things. When you're standing there answering questions, it can feel like the fastest way out is to explain everything clearly, to be open, to demonstrate you're not a difficulty. But legally, that instinct functions against you more often than it helps. Because once your words are recorded, they don't carry your tone, your intent, or your context. They're interpreted based on how they fit into a legal framework, and that framework is constructed around proof, not explanations. That's why the simplest approach is often the most effective. You comply with what's required. You remain calm and respectful, but you don't go beyond that. You don't fill silence with information. You don't try to fix the situation with more talking because the reality is nothing you communicate in that moment is going to improve your legal position, but it can absolutely make it worse. And this isn't about being uncooperative. It's about being precise. It's about knowing where your responsibility ends and where your rights begin. Because once you comprehend that boundary, your decisions become much clearer. You're not guessing. You're not reacting emotionally. You're following a structure that's designed to protect you. Now, I want to bring this back to you for a second because experiences vary, and what occurs during these encounters can look very different depending on the situation. If you've ever been stopped and inquired about a firearm, think about how that dialogue went. What did you communicate? How did the officer respond? And knowing what you know now, would you handle it differently? If you feel comfortable sharing, drop your experience in the comments. Not for debate, but so other individuals can learn from real situations and see how these interactions actually play out. Because the more individuals comprehend this, the fewer individuals end up learning it the hard way. And if this helped clarify something that isn't always explained clearly, You can support the channel with appreciation and subscribe for more examinations like this, focused on real-world situations and how to navigate them without putting yourself at unnecessary risk. At the end of the day, this comes down to one principle: you don't protect your rights by communicating more.